Hello, Mark, I'm seeing that you're co-host. Can you unhost yourself?
Hi, Miriam. No, I don't think I can, but maybe I think
I-
someone already has.
That was
Terry
by
has.
mistake. People kept joining as I was trying to make Mary David a host.
Okay,
I didn't realize that. Thank you for pointing that out, but I did that, so he's no longer co-host.
so you've made Mary a co-host?
I can't find her.
Mary. You know, I've noticed a few people have signed in and signed out. Are we having some problems here? Is
I haven't
anybody
seen any
here, has anybody here gotten kicked out of the meeting? I don't see, Mary was here. Well, I'll give her a chance to sign back in.
No, I'm not putting my face on. Why? How many people? 32.
I
Great,
did see her before.
well, okay. We're having I'm going to ask the group, we're having a little trouble with our Zoom. Is there anybody here who is signed into the town account, Zoom account for a previous meeting that they might have been chairing? And if you are, could you please fully sign out of Zoom using the town account? Because
Someone signed in earlier and then I re-signed in, so whoever signed in previously should have been booted out.
okay.
Yeah,
All
I was booted out. Can you hear me?
Yep, Mary, you're here. Thank you. Great. And you've made Mary co-host? Is that right?
Now I have.
Okay, hi. Okay, we're gonna start in a minute as people are coming in. So Mary, while I'm facilitating the meeting, if maybe you could help Carrie keep an eye on the waiting room and making sure people are admitted quickly. Can you do that? Thanks. All right. Well, the commission is here, our consultants are here, and I think we're going to call the public hearing to order for 7 o'clock. This is the public hearing for the Shutesbury Conservation Commission meeting to review the draft regulations for the Shutesbury General Wetlands Protection Bylaw. I am Miriam DeFont, the chair of the commission. I want to thank everyone for coming and welcome you. I'm going to be facilitating this meeting tonight, and I have a few introductory remarks to make, and I'll review what the plan for the evening is going to be as well. I also want to welcome consultants that are working for the Conservation Commission tonight. We have Special Counsel Elizabeth Goodman. We have Patrick Garner, Janice Stone. Welcome. The commission's plan for tonight is going to involve a public hearing as well as a discussion and review from our consultants. We want this to be an orderly meeting, and we have a large group tonight, so I'm happy that everyone is here and that you have an interest in this. But I'm going to ask everyone to be mindful of some general housekeeping rules. If Zoom crashes for any reason or you get booted out, please try to sign back in with the link that you were given. Please remain muted at all times unless you're recognized, and use the hand raise function in Zoom. If you are on a phone and cannot raise your hand, you may unmute yourself and ask to be recognized. We ask that everyone list their names on their profiles for the minutes and to identify yourself when speaking. After my remarks, you will be hearing from the consultants who've been advising the commission, Patrick Garner, Janice Stone, and Attorney Goodman. And after that, we will open the floor for public comments. I'd like to share the commission's policy on public comments for public hearings. Commenters must be recognized by the chair before speaking. Questions and comments should be directed to the commission. The chair will determine if another participant should respond. Depending on how many comments we have this evening, we may not be able to answer all of the questions that may get raised. However, the commission will endeavor to take note of these questions and to publish a Q&A document on our website following this meeting. Each commenter will be allowed 2 minutes to respond. There will be a hard stop at 2 minutes. Mary David, one of our commissioners, will be keeping track of time and will give a 30-second warning to the speaker. Commenters may, at the discretion of the chair, be allowed a second time to comment if time permits. The purpose of this hearing is to gather information to assist the commission in developing regulations for the Shutesbury General Wetlands Protection Bylaw and to allow the public an opportunity to make comments. Primarily tonight, we are here to listen. We will not be making any final decisions regarding these regulations this evening. The public comment period will remain open for another 10 days after tonight or the end of business on Thursday, September 28th. Please note that tonight's hearing is not about adopting a new bylaw, which would be under the purview of a town meeting vote after approval by the Select Board. The Conservation Commission supports the development of an updated bylaw and has in fact already drafted a new bylaw, which we have submitted to the Select Board and posted on our homepage. Our homepage at shutesbury.org/concom has a link to a dedicated page about these regulations with drafts, commentary, and other educational resources. To summarize why we're here tonight, the commission has a statutory charge to protect vital water and wildlife habitat resources, both under the Shutesbury Wetlands Protection Bylaw and the State Wetlands Protection Act. The bylaw was adopted by the town in 1987 and approved by the Attorney General's office. Towns are allowed to adopt local wetlands bylaws that are more protective of the environment than state law. Among other things, this bylaw protects water quality, water quantity, wildlife habitat, and the prevention of water pollution and stormwater damage. We do this by reviewing and permitting activities in certain protected areas of town called wetland resource areas. We also review activities in the 100-foot area around wetlands, often referred to as the buffer zone or the adjacent upland resource area, or ORA for short. The commission has been working for over the past 2 years to update the bylaw regulations. The current regulations, which are very brief and badly outdated, were adopted 23 years ago. Regulations are a separate document that supports the bylaw with procedures, rules, definitions, permitting details, fees, and scientific standards. Regulations are the rules adopted by the commission to ensure that decisions are made in a reasonable, systematic, and scientific manner. Fees collected for permitting activities go into a dedicated town account and are used for administration of the bylaw. The bylaw allows the commission to adopt regulations from time to time and to update them. In fact, they really should be updated every 5 years or so to keep up with evolving scientific standards. The bylaw requires commissions to draft regulations by holding a public hearing and then adopting them. As is typical, the draft regulations have undergone many stages of revision, often in response to public comments. Many hundreds of hours of hard work have gone into these draft regulations. The regulations under consideration tonight were developed in conjunction with our technical advisors, wetland scientist Patrick Garner, Janice Stone, and Commissioner Beth Wilson, and with input from our special counsel, Elizabeth Goodman. I want to thank these consultants for their diligence and hard work. Before we go into more discussion, I would like to just recap the history of this effort for this public hearing and for the record. In January of 2021, the Commission began discussing the need for new regulations. In 2022, our town council, Donna McNichol, advised us during an ANRAD public hearing for the proposed solar projects that we needed to update the regulations as quickly as possible due to their being too incomplete and lacking in necessary definitions and standards. Also in 2022, we learned of a court case of Boston versus Quincy that resulted in a legal precedent that now requires commissions to adopt detailed regulations in order to administer their bylaws. The commission completed this draft, the first draft, and posted it for public review in May. In July, we held a public hearing on the regulations and also received 2 legal reviews from a special counsel hired by the select board and from a municipal and land use attorney hired by a group of private residents. In August, the commission obtained a legal review itself on behalf of the commission by special counsel Elizabeth Goodman, a highly experienced land use and municipal attorney. When she began her review, Attorney Goodman was given all the drafts and previous legal reviews and commentaries that the commission received. She advised some changes to the regulations, both after her first round of review, and then again more recently, after she reviewed a second legal review that was provided to the commission from the select board. The draft on our website reflects all of these changes and updates. Attorney Goodman is here tonight to speak about her review and recommendations. And with that, I'm going to turn over the discussion to her, who is going to make some remarks. And then we'll hear from our technical advisors. Welcome, Beth.
Thank you. Thank you for involving me in this project. It has been the subject of some controversy, as I understand it. You have a lot of almost 100 people participating tonight, and the importance is evident with all of this concern. But I do feel strongly that it is helpful to the commission to adopt these regulations. It's helpful because of for example, the City of Boston Quincy case that you mentioned, which went to the Supreme Judicial Court on the allegation that a local commission, Quincy, had tried to overturn or stop a project that the DEP had approved. And the court held that the local commission did not have a clear articulation of its bylaw standards that were different from DEP. And so nothing the commission did counted, essentially. So without clear defining regulations, this town could become involved in litigation over its authority to issue any order under the local bylaw, and also be challenged for its failure to act appropriately under the orders, under the bylaw. So I really feel it is the regulations that I reviewed have been similar language in many towns. It's not like you're inventing new language that is expansive or different. It's just explaining your authority under the existing bylaw. So I believe these regulations are more helpful. Yes, it would be wonderful to have a bylaw that identified all of the comprehensive areas in which you want to express your protection. But these regulations are not adding fuel to a fire. They are helping to put it out. They're not bans. They're not prohibiting activity, but they provide a clear structure for future commissions, this commission and other commissions, to review under the local bylaw. So yes, they are detailed and comprehensive, but I believe that these support the work of the commission and that you would be in risk of becoming involved in litigation if you don't have a clear, and that's why we have regulations, a clear and precise method of review. So that's sort of my overarching comment. I don't know if you wanted me to say anything else, Miriam, but I know there are other areas that have come up as controversial, and I'll wait
Yeah.
till those.
Yeah, we'll
brought
we'll
forward.
move into those. I guess one question that has been posed by the public is, why don't we just wait and stop doing anything? Why don't we just stop working on these regulations until such time as a new bylaw is adopted? What would be wrong with that? And if the bylaw is outdated, why don't we just stop using it? Could you explain to the commission what the consequences of that might be?
Well, you have a duty as a commission. You've been charged with the protection of wetlands in your town, and surely no one is saying to you, ignore the bylaw, which was passed by the town residents of Shutesbury. No one is seriously saying to you, I mean, I know I've read the comments of other attorneys, Attorney McGregor, Donna Brewer, and many comments. No one in the legal profession would be saying to you, just give up and stop reviewing wetland notices of intent under your local bylaw. So since you have that duty and that charge, you need, it's best to define it appropriately so that you're not shown to be arbitrary or capricious, that you have a factual structure or an analysis and a process. And then you can be judged on, whether you've complied with your regulations or whether your regulations maybe even are suitable. But you do have in the regulation, the ability to look at each circumstance and to make decisions based on the circumstances before you. It is not, like I said, nothing in this regulation is a ban. There are waiver provisions. There are provisions for you to advise people in advance of filing a notice of intent. And so I think it would be wrong of the commission to just have no regulations.
So would it be safe to say that if we were to choose to not adopt regulations at this juncture and wait, let's say, several months until such time as a new bylaw was adopted by the voters of Shutesbury, that the decisions that we would be making under the bylaw might be open to greater scrutiny because we chose not to adopt new regulations?
Yes,
That'd be safe to
if you
say.
have no regulations and you issue decisions under your local bylaw, they can be subject to challenge. It's no protection to say not have regulations, right? Because your decision is judged on whether you're arbitrary and capricious. And if you just say, if you don't have any definitions or process or method of reviewing your duties, then you are subject to challenge just as well. It's a risk that I wouldn't advise you to taking.
Okay. Before we move on, commissioners, is there anyone from the commission who has any questions? Or our consultants for clarification? Okay. The plan that we had in order to structure our discussion tonight, we had a public hearing in July, and the minutes are not quite ready for them to be available for the public, but the recording of that public hearing is available on Zoom for anybody on YouTube, if anybody wants to review it. And we had a lot of initial kind of educational material at that public hearing, and Patrick Garner, our consultant technical advisor, was present and gave a presentation. So I don't want to repeat that and duplicate that, but we thought that perhaps the most efficient use of our time is to really drill down to some of the specific concerns that were raised by the recent legal review that the Conservation Commission received last week, and that both Patrick Garner and Attorney Goodman have now reviewed, and hear from both of them about their responses and concerns and how we can best address those issues. Is that agreeable to the commission? Everybody's okay?
Yes.
So I think we'll do it in order. And what I'm going to say to the public is that there is a document that's available and it's been circulated to the town with a list of legal concerns from Attorney McGregor on behalf of the Select Board. And we're not going to recap those. Those are available on the town website, I presume, or upon request to the Select Board. But we're going to address some of those concerns and how our regulations either deal or don't deal with those concerns. And so I'm going to just take it sort of in chronological order. And the first concern and series of comments had to do with vernal pools. Attorney Goodman, do you want me to respond to this piece of it, or would you like to make the initial comments? But I also want to hear from Patrick Garner.
I thought that Mr. Garner was going to address that it was a scientific question. But I'm
Yes,
happy to
yes.
comment if you want.
Well, I'll just make a couple of statements, explanatory statements in terms of how the commission has understood how we are addressing vernal pools. We have defined vernal pools, and we'll hear from our technical advisor as to his opinion about this methodology, as a type of isolated wetland. And isolated wetlands in the bylaw are specifically a protected resource area. Vernal pools have special importance for the values of the bylaw, which we can hear from our technical advisor about. And so in Article 4, the vernal pools section is set apart from freshwater wetlands, really for the purposes of clarity, but not because we're considering it to be something different than an isolated wetland. It's a special kind of isolated wetland. But because it has its own unique definitions and performance standards, we put it in a separate section. And that's the way we organize these regulations, because it seemed to read better and make the most sense doing it this way. And then the other sections of Article 4 break down other protected resource areas. So Patrick, could we hear from you? I'd like to introduce you at this point. And I think the question that the commission would have is, are we appropriately defining vernal pools as a type of isolated wetland, and why are they critical? And why are these protections important? And if you can comment on the particular protections that we have in this regulation, that would be helpful to us.
Sure. So good evening.
Perhaps we should stop with an introduction of you for people who are not familiar with your background. So I'm going to blow it, but please add if I've missed some important things. But Patrick Garner is a hydrologist and wetland scientist who was a past president, I think twice, of the Massachusetts Association of Conservation Commissioners, and has worked statewide with DEP and other regulatory agencies in developing statewide standards, and is a highly experienced wetland scientist. And if I've missed more, please correct me.
Okay, well, I think it's fair to say too, because Greg McGregor has been a focal point over the last several weeks because of his participation with the Board of Selectmen, that Greg and I know each other. We're friends. We have both served for many years, 15 to 20, in fact, with MACC, the Mass Association of Conservation Commissions. He and I were both president. He and I have both been on DEP technical advisory committees. And we have both worked together on projects, and we have worked in opposition as experts in the field typically do. So I have great respect for Greg, but I think it's fair to say that we know each other well. So with that sort of addition to my bio, thank you. Vernal pools. So we have a lot of people on the call, and vernal pools are probably somewhat confusing in terms of what they really are. Let me try to be succinct, but explanatory enough that I sort of don't leave people confused. So a vernal pool is a body of water. It's often isolated. It is sometimes found within wetlands itself, but vernal pools are a sort of an epicenter for the breeding activity of frogs and salamanders. Many of these species are endangered, some are not, but vernal pools have to have what we call a hydro period. They have to have water in them for a minimum of 4 months. And that 4-month period is necessary for the egg laying to occur, which always happens, the period of time that goes by before the eggs turn into tadpoles, and then in turn, the tadpoles turn into sort of young salamanders or very young frogs who continue to live in this pool until they're old enough to migrate out. So that sort of excludes puddles, which I've seen in some of the letters of concern that you've forwarded to me. A puddle typically is not going to be deep enough, large enough, and sustain water over that 4-month hydro period in order for this period of time to go by. Vernal pools are certified by a state agency called the NHESP, the National Heritage for Endangered Species Program. And they require exactly the criteria that I'm talking about for vernal pools. Vernal pools need to have a sort of a selected protected area around them, because the species that use these areas for the breeding don't live exclusively in these pools through the year. In fact, they only come down to the pools for a short period of time, and then they retreat back to the upland. So there's a correspondence between uplands and wetlands. And typically the correspondence is that either the salamanders and or frogs that depend on these vernal pools live 95% of the time in the adjoining uplands. And they come down to the pools during breeding season, and then they leave after they've had their fun and laid their eggs, and they go back to where they came from. So the protecting that upland area is critical for the maintenance of the pool itself. If the upland is destroyed, the vernal pool itself ceases to function and becomes essentially a dead zone. So protection is important. It's also very typical. It's important to say that under the Wetland Protection Act, the state legislation and regulations that DEP uses, the vernal pools are protected. There's typically a 100-foot buffer zone outside of any vernal pool, and any activity within that 100 feet is reviewed by DEP to look at potential impacts. Towns with bylaws almost invariably and without exception protect vernal pools, and it's very common for towns to exceed that 100-foot zone. I was working last week on a project in a town in central Massachusetts that has a 150-foot no disturb zone around vernal pools. So I think what the town is proposing in its draft regulations is not unusual, and it's as you and I have talked about, Miriam, my push as a wetland scientist would be for an even larger and wider buffer zone to protect these species. As we talked about in the last hearing in July, it's not unusual. Can you hear me?
Yeah, I'm seeing that Beth Goodman had her hand raised, so I think she had a question for you.
Okay,
I do.
Beth, before you go on, let me just
Go
finish
ahead.
my comment, and then I'll cede to you. It's not unusual for these species to migrate anywhere between 400 and 800 feet outside of the pool during their annual cycle. So, the 50, 100, 150 feet, the different towns and DEP use for buffer zones is really not protective enough, but the state tried to strike a sort of practical balance between what is necessary to protect these species and what is practical in terms of real estate values and that sort of thing, and private rights. So with
Beth-
that comment,
Beth, what was your question?
Thank you. Thank you. Well, the reason I said that the comment about the ability to regulate vernal pools is a scientific question is that my question, which I think Patrick has answered, is that vernal pools are a type of isolated wetland. Is that fair to say, to characterize a vernal pool as a type of isolated wetland?
It can be, but it's not always. Sometimes vernal pools are found within wetlands themselves. Sometimes they're found outside of the wetlands. So it's important to be able to classify them in that respect.
Well, so we have to look at the language of the bylaw. And Mr. McGregor said the bylaw doesn't mention vernal pools. What the bylaw mentions is any freshwater wetland, isolated wetland, marsh, wet meadow, bog, or swamp, or within 100 feet of any freshwater wetland, isolated wetland, marsh, wet meadow, bog, or swamp. It's more, there's other things, but those are the ones that would apply. And so I guess my question would be, is it possible for a vernal pool to occur outside of either freshwater wetland, isolated wetland, or marsh or wet meadow or bog or swamp?
Yes.
So how would that be? Wouldn't it be an isolated wetland then?
Let me jump in because I think I see where we're getting confused here, at least in the way we've discussed it. And maybe Patrick, please correct me. But what we have discussed is that there's different types of isolated wetlands. Vernal pools are one type, and that there are other types that are vegetated. Vernal pools don't have to be vegetated, is my understanding. They have these very specific definitions based on their capacity to be breeding habitat. But I think what you're saying, Patrick, is that they can be located also within other resource areas or other kinds of wetlands, like a floodplain or even in a BVW. Is that the point you were trying to make?
Yes, that's correct. And as Beth asked correctly, they can be completely isolated in an upland area that has a depression itself that may be a catchment for rainwater, groundwater contact. So they may be within an existing wetland, they may not be, and they may be isolated and in an upland area.
Okay, thank you. Beth, I see you have your hand raised, and then I think we'll move on to the next topic. Beth Wilson.
Yeah, I just wanted to mention that vernal pools are also sometimes identified within the isolated land subject to flooding resource area.
Yes.
So, you know, if that's in our bylaw, that's just another resource area that they can be categorized under.
Yes.
Yeah, I agree completely.
Yes.
Yeah, in fact, that's a frequent debate when a vernal pool is.
So one of the things that we talked about when you and I were discussing this, Patrick, is that in section 3.22, where we discuss vernal pools, we have some exemptions for protections of vernal pools, particularly areas that are within previously landscaped or developed areas, or where the buffer zone, or if you will, the aura of the vernal pool is penetrating into a previously developed area. So one of the concerns is that we're somewhat, it's been alleged that we're regulating every puddle everywhere in town. And I'm wondering, and when you look at these regulations and your familiarity with regulations elsewhere in the state, do you think we're unreasonably regulating vernal pools?
Well, I think you're clearly exempting areas that are already developed. And that's as you should properly. And I don't think you're by any means capturing every puddle in town. As I said in my earlier comments, these so-called puddles have to be large enough and substantial enough dimensionally to be able to hold water to a depth of 18 to 36 inches at a minimum for a period of at least 4 months.
Okay.
So that requires a fairly large body of water. That's not going to be a puddle.
Thank you. Thank you. All right, I think we're going to move on to the next topic. And that was, there are two, and I'll handle this piece of it, I think, because this is very brief. There were two comments in the legal review from Attorney McGregor. One was that he questioned the way in which we were describing the burden of proof and the evidentiary standards in the regulations, because in certain places in the draft, we had the term clear showing of evidence. And he was interpreting that to mean the same thing as a clear and convincing standard of evidence, which is a very high bar, and it is not the plain language of the bylaw. And in reviewing this and discussing this with Attorney Goodman, we recognize that that was never our intention to raise the evidentiary bar. And we were not interpreting that language to mean this higher bar. And so we've edited out all of those references. So there no longer are any references in our draft to a clear showing of evidence. And I think that that seems sufficient, and Attorney Goodman has agreed. Beth, would you agree that that's sufficient for that item?
Yeah, you deleted the references.
Yes. And then there was also some concern about a section in our regulations in Article 3, Section 3, where we originally were calling it practicable alternatives and alternatives analysis. And this was a section where we were describing a process whereby applicants would review with us in their applications the efforts that they were taking to avoid, minimize, or mitigate. And that they would consider other options or alternatives and be able to kind of give us an explanation of how the option or alternative that they were choosing for their project was the best option, or maybe the only option, that maybe there was no other option available because it would just be too expensive or too impractical. And Attorney Goodman advised that that was a little confusing because the Wetlands Protection Act regulations also refer to alternatives analysis and practicable alternatives. And so we kind of didn't want to have that kind of confusion. And so she suggested that we just change the language. And so we changed the title of that subsection to consideration of reasonable options, and we shortened it considerably to make it as clear and straightforward and not very detailed. And Attorney Goodman advised that this seemed quite sufficient. Do you want to comment on that, Beth?
So the Riverfront Protection Act was passed later than the regular Wetlands Protection Act, and it imposed a different standard in the riverfront area. And it can include alternatives of not developing, of showing that there's no other site, even off-site, where you can do your project. And that's too great a burden, I agree, for the normal bylaw review that you're going to do in this circumstance under your local bylaw. It wasn't what you wanted. What you wanted to show is that applicants were taking the right steps to mitigate their impacts, right?
Yeah.
Because the prohibition is on altering. So if they're altering the least that they really possibly can, that's the kind of analysis you wanted. You want to see mitigation of environmental harm. That's certainly within your authority. And I think that expressing it as in that way, we want to see options for mitigation, is appropriate. So yes, that I approve. I thought that was better than referencing the state regulation, which has different implications.
Which has very special meaning and would be
Yeah,
confusing.
special meaning. And
Yes.
again, that's like the City of Boston versus Quincy case. Specific terms that you're trying to say are different from the standard of the state should be explicitly laid out, and the commission should be able to rely on its own regulations in making a decision under those.
Okay, thank you. All right, the next comment had to do with, and we're kind of segueing right into this, cumulative effect and the legal test established by Boston versus Quincy. And this is a question for Patrick Garner, basically. And the question, I guess, was posed in my conversation or a review with Attorney Goodman, that we would like to know from you, in your review of these regulations in their totality, do you as a scientist find that they are scientifically defensible and objective and substantive?
Basically, yes, they are, and they're not simply scientifically, but practically. DEP, and I've been involved in several appeals before DEP where we had a large tract of land. I'll give you an instance of perhaps 100-acre tract of land, and a developer will come in and begin to slice that up and present to the commission 20% of that, and perhaps have a very intense use that would be intense enough to be typical of a 100-acre development. But they do this on 20 acres, and the commission says, fine, we approve it. And then 6 months later, they come in with another chunk of the 100 acres that is equally intense. So DEP set ground rules quite a while ago, allowing a commission to look at cumulative effects on sort of foreseeable development on the entirety of a parcel. So what the commission is proposing in its regulations echoes that and strikes me as being very typical and very practical.
Thank you. All right. Was there anything you wanted to add, Beth, where we move on to the next comment?
Well, this is where you get into the idea that, well, if we could alter the bylaw, we would say the bylaw, we're specifically going to look at cumulative impacts. And that's, so there is reason that you want to update your bylaw. The same thing with,
Beth, doesn't the bylaw say significant or cumulative effect? That's the language in the bylaw. That's the standard. That's where I'm a little confused.
I'm checking.
In the first section of the bylaw.
Yeah, for failure to avoid or prevent unacceptable, significant, or cumulative effect upon wetland values. So you are empowered to deny a permit based on cumulative effects. The issue in the Boston versus Quincy case is that the commission had no regulations to define what that meant and how that would be any different from DEP's review when DEP had denied that project. So your commission should have these regulations to define that analysis. So yes, I think it's wrong in Mr. McGregor's comments. I was looking at his comments saying you need to amend your bylaw to use those terms, but I see it right here in your bylaw.
Thank you. All right. The next comment had to do with stormwater management. We're not going to be taking any comments from the public until we get through this review with our technical consultants. So folks, I just ask you to hold on until we get through this. So there were concerns about our discussion of best management practices, which are a type of stormwater structure in Article 3, Section 8. And there was also some comments from Mr. McGregor that we were trying to, in some way, bootstrap a stormwater bylaw into our regulations illegally beyond the scope and jurisdiction of this bylaw. So I would like to ask Beth about this. My understanding is that we are not creating any new BMT types because we're adopting the Mass DEP stormwater standards, which subsume the Massachusetts Stormwater Manual, which includes BMP designs and types. That we're not regulating stormwater everywhere in the town. We are regulating stormwater to the extent that it impacts resource areas. Is that your understanding, Beth?
That is my understanding, that the regulations themselves are implementing wetlands protection, and to the extent that you need to have methods of managing stormwater so that it doesn't, so an alteration doesn't result in harm to a wetland resource value, then you can adopt appropriate, reasonable, commonly used standards and apply them in your town. And you probably are doing that anyway. You just don't have it in a regulation.
So you did not agree with this comment, those series of comments about stormwater in his review?
So it's always helpful to have comments. And one of his comments are, we should probably have stormwater BMPs throughout the town, not just for wetland resource areas. And so I would say, sure, that sounds great. Do that. But he doesn't say You know, he says a better approach would be to enact a stormwater bylaw. That may be true. I'm not going to say his comments are wrong. What I'm going to say is it doesn't make these regulations illegal.
Okay, thank you.
Yeah, Miriam, can I clarify something as well?
Yes, please do.
This is more of a comment for the public, but the commission already under the Wetland Protection Act has the ability to regulate stormwater in areas that could potentially impact wetland resources. So if you have a catch basin stormwater system that drains into a wetland, you have already the protection that the jurisdiction over that area. So that's not something new that you're inventing or reaching out for. You're simply clarifying and defining precisely what those boundaries are. And I think that's appropriate, but the commission has outreach into those areas now. They're not within 100 feet or 150 feet. They may reach out hundreds of feet depending on the stormwater system itself. And as Beth says, if that system has discharge that has the potential to impact the wetlands, that's something that you already have the ability to look at and analyze. So it's nothing new.
Thank you.
And if I could just comment again, we've talked about this, but it is a very complex setup. And that is the commission, even without a local bylaw, is empowered to be the local authority under the State Wetlands Protection Act. Everyone should keep that in mind. Even if you didn't have a local bylaw, this commission would exist and it would be protecting wetlands using the state standards. So all we're doing here is saying we also have a more protective local law, and we want to be clear about the standards imposed under that. It doesn't take away from your state authority. It's been determined by law that bylaws can be more protective and so you're always going to have the state standard.
But we're not trying to undo the state BMP.
You can't.
Right. So that's why we are adopting the stormwater standards and incorporating the stormwater management manual from DEP so that there's consistency in the way that we review these kind of stormwater.
Correct. And that's why I said you're probably already doing it.
Yes. Okay. Thank you. Okay. Can we move on? Do you think there's enough discussion, Beth, around this particular comment? Was there anything else we missed?
Yeah, I have no questions, further questions.
The sixth comment had to do with the delineation method for hydric soils. And this is really a question for Patrick Garner, because Mr. McGregor was commenting or observing that it's a very complex methodology to delineate or identify the boundaries of BVW using hydric soils, and that perhaps this was too complex or confusing for the public or for these regulations. So we would like your opinion about it. I will just say as a public comment that our commission learned very recently in an ANRAD with the town on a disturbed site that hydric soils were extremely important because it was the only methodology for delineating a wetland on a property where the site had been disturbed and vegetation had been mowed. And so the usual other methods, and it was a drought. So we couldn't go by surface hydrology and we couldn't go by hydrophytic vegetation. The delineation had to be done by hydric soils. So anyway, Patrick, in your review of and I know you assisted us in developing this regulation, but do you think that the definitions and standards that are being used are scientifically valid and capable of being understood by a wetland scientist?
Eric has his hand up.
Yes. Well, Eric, did you have a question?
No, I just had a comment that apparently we've reached our limit of 100 people, 100 participants, and people cannot get into this meeting who want to get into it. I've just heard that. I'm passing it on. I'm not sure what we do about that, but there we are.
So I reached out to Grace once I realized that we were getting to 100 people, and she confirmed with me that we're allowed up to 300.
Well, people are not getting on. I can't, that's all I can, I'm just passing this on.
Well, maybe I don't know what we can do about that.
Well, what I was talking to Grace, because I was concerned about this once you hit 100, and she told me that it was 300, that if we aren't allowed to admit everyone that's willing to participate, then we would have to reschedule.
And I see somebody from the web committee. Gail, you have your hand raised.
Yes, the people are being told the meeting is full and not being allowed in.
I'm going to call Grace, just one moment.
Okay, well, let's just proceed until we hear back. So Patrick, could you respond to the question I had about, did you want me to repeat that?
No, I got it completely. You were asking about hydric soils and whether the regulations are unusual or are overly complex.
Yes.
And my quick answer would be, first, Greg is many things, but Greg is not a soil scientist or a wetland scientist. Hydric soils are a complex topic, and so the public understands hydric soils are typically referred to as soils that have changed in color because of their contact with groundwater. And so wetland scientists and soil scientists can take samples of these soils below the surface and tell whether or not they're in a probable wetland zone. It is complex. It's nothing that the public should expect to be able to understand quickly and readily. It requires a lot of educational exposure to these workshops, seminars, and lots of experience. But that being said, under the DEP wetland regulations, there are 3 methods that must be brought into every wetland delineation. And that is looking at surface hydrology, which is typically standing water, hydric soils, and wetland vegetation. And you take a balance between those 3, and you've got to have at least 2 out of 3 of those elements. So the hydric soils are what hydric soils are. They were adopted originally by the Corps of Engineers, then by EPA, and then by DEP in turn. And they're something that every wetland scientist uses. The definitions in the regulations would be quickly and commonly understood by any wetland expert in the field, and they're not overly complex in my opinion at all. They're very typical. Thank
you. All right, let's move on to the next comment, which would be I'll respond to this one, having to do, there were comments 7 and 8 had to do with some language in the regulations regarding wildlife habitat and endangered species. And in response to Attorney McGregor's comments, the commission has deleted the paragraph that was Article 3, Section 10, paragraph 10.23. So that that has been addressed by removing it from the draft. Carrie, did you get any resolution about the size of the meeting?
So I've been still admitting people, so I'm not sure why that's occurring. I just admitted 3 people, so Carrie and I are both admitting people.
It does.
Sorry, I was on the phone when you were asking me. But yeah, I have confirmed that it is 100. So unfortunately that we can't hold as many people that are trying to get in. And from my understanding, from what me and Grace discussed, that we would have to postpone and reschedule the meeting. We'll have to upgrade the Zoom account to make sure that it has a capacity of 300.
Yes.
And then continue the meeting.
Please mute yourself. What I would like to discuss with the commission is whether we want to proceed at least with the attendees that are here. Beth, what would you advise us to do?
I would advise that you continue the hearing.
Okay.
Because because we noticed it, we told people they could participate, and then we're excluding them from, so you should continue it until you can accommodate.
So I do want to make an observation, which is that we were given authorization to hire you, Beth, for a review that included attending this public hearing, but we have no authorization to bring you back for a repeat public hearing, nor do we. So that is a concern because we haven't finished going through your review and comments.
Well, I believe it's the same, it will be continued, so it'll be the same public hearing. You're just going to continue this public hearing. You
Okay.
should pick a date now. You should just continue the hearing and we'll stop right now and we'll confirm. That's what we have to do. C'est la vie.
All right, well, I would like to propose to the commission that we continue it to the 28th, which is our next regular meeting. We could perhaps do it a little earlier.
Yeah, I mean, I have a conflict with Tuesday night, but I could do Wednesday, September 20th. That was,
The only problem is actually Thursday night, Janice Stone is usually not available because she has another work
20th
commitment.
is a Wednesday.
Wednesday, September 20. That was in my calendar as a possible hearing date still,
Would we be able to post it in time? Because it's
48 hours.
48 hours, would it, unless we did it at 8
Well,
o'clock.
yeah, I think it's okay because you are announcing in this public hearing that you're going to continue it because of the lack of access and, you know,
Miriam, so you know, I'm not available either Wednesday or
That
Thursday.
was-
night.
that
I'm
was-
available.
oh,
I knew there was an issue.
Yeah.
so
And
then
what
that's
about-
not good. No,
what
I
about
think I
Wednesday?
definitely,
What about Wednesday, the 27th?
I think I have a conflict. Yeah, no, wait, Wednesday, the 27th, I'm okay.
I'm okay as well.
And Janice?
I think I am. I'm going to go check my calendar.
How about Beth and Mary and Robin?
Yeah,
I'm
you-
fine.
I can do the 27th.
Okay, that gives us enough time to post it. So
Yeah,
what
that
time
gives you plenty of time.
would you guys prefer to do it earlier? Do it 6 o'clock?
Sure,
Yes.
Yeah.
Easier for
my brain
everybody?
works better earlier.
What? All right. So we're going to make we are going to, so for the public to understand, we are going to continue this public hearing, which means we are going to end it tonight. Unfortunately, I'm sorry, we're not going to entertain comments. But we will be meeting on the 27th at 6 p.m. by Zoom. Janice, you have your hand raised?
Yes, I can do 27th.
All right, hallelujah. All right.
So this meeting was recorded, so the first part of it will be available to anybody who wants to review the first part.
Absolutely. Absolutely. For anybody who was not able to be here at this meeting.
So
And I
you're
you-
continuing, your board should vote, I think, just
Yeah.
to,
And what I was just gonna say is I will put out a town-wide announcement. And I will make sure in that announcement that people understand that they can go to the Zoom YouTube recording for the first half of the meeting. So that people who wanted to be here would be able to familiarize themselves with it. Carrie, did you have your hand raised?
Yeah, just a small comment is that I confirmed with Grace that the one of the other accounts, I believe, may have 300 participant limit. So we're gonna investigate that and make sure, and if not, then we'll set up a new one.
Okay, excellent. Thank you. Okay, so I'm sorry, everybody. I appreciate everybody's patience. Thank you, Patrick and Beth, for being here tonight, and Janice and the commission. And I look forward to being able to continue this.
Miriam, I think as a matter of form, your commission should vote to continue the public hearing till
We're gonna do that.
27th.
So I'll
PM.
make a motion to
Motion.
continue the public hearing till 6 p.m. on the 27th.
Okay, is there a second?
Second,
David, I.
Aye.
Defont, I. Harrington,
You're
Yes.
muted, Robin.
you're muted, Robin.
aye,
And Wilson.
Okay,
aye.
Okay.
I'm satisfied.
Right
Thank
now we
you.
need a motion to adjourn. I will move to adjourn this public meeting tonight. We've already closed we've continued the public hearing. Now we're gonna end the public meeting. I'm making a motion, and will somebody second it?
Second,
Second,
Okay, David,
aye.
I, Harrington,
Aye.
and Wilson.
aye.
Okay, thank you, everybody, and thank you for your patience, and we look forward to seeing you very soon. All right, good night.